All rise.
Madam Registrar, please call the case.
The Arusha branch of International Residual Mechanism for Criminal Tribunals is now in session.
Please be seated. Good afternoon. I'm Judge Joensen, the single judge assigned to this case. And may I now please have the appearances of the parties. First, the prosecution.
May it please Your Honor, the prosecution is represented by me, Veronique Wright, Senior Legal Officer, Mr. Rashid, Legal Officer, Ms. Tembile Sagahote, Legal Officer, Ms. Stavrula Papadopoulos, Legal Officer, and Ms. Irene Bully, Records Management and our Case Manager.
Thank you, Ms. Wright. And now the defense, starting with counsel for Mr. Maximilien TURINABO.
Good afternoon, Mr. President. My name is Stéphane Vagn, counsel from Montreal, Canada. I represent Maximilien TURINABO, who is present and sitting by my right. Thank you, Mr. President.
Thank you, Mr. Vagn. And then we continue with counsel for Mr. Anselme NZABONIMPA.
Good afternoon, Your Honour. My name is Jeffrey Roberts, representing Anselme NZABONIMPA, and good afternoon to everyone in and around the courtroom as well.
Thank you. And we continue with counsel for Mr. Dieu NDAGIJlMANA.
Good afternoon, Your Honour. I am Wilfred Nderitu from the Kenyan Bar. Mr. NDAGIJlMANA is on my right. Thank you.
And counsel for Ms. Rose FATUMA.
Good afternoon, Your Honor. I will be representing Rose FATUMA in this case. Thank you.
MUNYESHULI.
Good afternoon, Your Honor. Kurt Kearns appears on behalf of Dick Prudence MUNYESHULI, who also appears in person. On my left is Dragan Ivitech, who also represents the accused, as well as our legal assistant, Laura Luca.
Thank you. Yes.
Thank you, Mr. President. My name is Dieu NDAGIJlMANA.
Is anyone in charge of the headphones? They're not connected here. What? Please come and connect my headphone. Oh, you. Okay. Yes, Mr. NDAGIJlMANA, you were saying?
Thank you, Mr. President. As I was saying, my name is Dieu NDAGIJlMANA. I am sorry I cannot hear you, says the accused person.
Is there now? Sorry for this. Please continue.
I was saying that Mr. Wilfred Nderitu, who is sitting here besides me, and myself were unable to collaborate the way we should have, and have already presented this situation to the relevant authorities, and I have explained in detail what led to our lack of collaboration, and I've already explained this to the registrar. I sent 3 letters to the registrar, the first of which was dated 24 October 2018. The second one was dated 9 November 2018. And the third one was dated 14 November 2018. I also explained the situation to the staff of the registry who visited me on the 21st of November 2018. I was also paid a visit by the staff of the registry on the 7th of December 2018, and on that occasion they informed me that I had a right to choose. That was on the 5th of December 2018. So they granted me leave to choose a new lawyer, and subsequently I sent 2 other letters. I drafted the first one in the morning, and the second one was drafted in the afternoon of the same date. And in those 2 letters, I requested that a new counsel be assigned to me. I had made 3 proposals, and the first 2 proposals were not accepted, but insofar as the third one is concerned, which concerned Lawyer Philpott,
request to have a new counsel has been granted, but it takes some time to appoint the new one. And in the meantime, the registrar has ordered Mr. Nderitu to represent you in these proceedings until the new counsel is available. So your request has been granted. And in the event you had any problems that the registrar denied your request, it would be the president and not me, the president of the mechanism, who you could complain to. So this matter is not really relevant to the proceedings today. So let us continue.
I will not understand what we have said. Can explain in
No, because it's not a matter for me. And I've been advised that your request to have a new counsel has been granted. And we are waiting for the new counsel to be appointed. And in the meantime, Mr. Nderitu has been ordered to continue until we get the new counsel. So we will continue today with Mr. Nderitu assisting you. But thank you. Please sit down so we can continue. And before we go further, I want to know if the accused are following the proceedings in a language that they do understand. We have an agenda for today, so we are going to take the issues one after one. You have anything you need to say now, Counsel?
Yes, Mr. President. I am representing Madam Rose Fatuma, as I mentioned a short while ago. Apparently, for technical reasons, we cannot follow the deliberations in Kinyarwanda, which is the only language that she understands. If the technical services could assist us to sort out this challenge, we'll be grateful, Mr. President. Thank you.
I understand it's a technical issue and not the lack of translation.
Mr. President, I've just been told that the matter has been addressed.
I go on. I would like to remind the parties that certain information in this case is subject to protective measures and confidentiality orders. This includes confidential information that has been redacted from the indictment as to the identity of certain individuals and the basis for the review proceedings in Ingabatuara case. Confidential information should not be disclosed in open session. To the extent a party is required to refer to any confidential information, you must first indicate the need to go into private session to ensure appropriate measures are taken to prevent public disclosure of confidential information. The initial appearance of the accused was held on 13 September 2018. Today's status conference is being held in accordance with Rule 69A, which requires a status conference to be convened within 120 days of the initial appearance of the accused and thereafter within 120 days after the last status conference. The purpose of the status conference is to facilitate exchanges between the parties so as to ensure expeditious trial proceedings, to review the status of the case, and to provide an opportunity for the defense to raise issues in relation thereto, including the mental and physical condition of the accused. Before we continue, I would like to briefly recount the main procedural developments in this case since the initial appearance. In particular, on 18 September 2018, I invited the government of Rwanda and the parties to file submissions on the suitability of this case for transfer to Rwanda. Following extensive briefing, I decided on 7 December 2018 it was not in the interest of justice and expediency to refer the case, and that it should instead be tried before the mechanism. In addition, I also issued numerous other procedural decisions and orders related to disclosure materials seized from Mr. MUNYESHULI pursuant to an arrest warrant and other confidential matters. With respect to pending litigation, I note that there are matters related to detention that are before the President, which will be adjudicated by him. As to pending litigation before me, I have observed that some submissions have raised questions as to my competence to adjudicate motions related to this proceeding, because particular rules of the Rules of Procedure Evidence refer to chamber or trial chamber instead of single judge. Article 12.1 of the statute makes clear that cases for contempt will be tried in the first instance before a single judge. Furthermore, Rule 2C of the rules specify that, quote, In the rules, trial chamber and chamber or chamber shall include single judges in accordance with Article 12, Paragraph 1 of the statute, as appropriate. In this context, I am the trial chamber seized of all first instance litigation in relation to this case and will proceed accordingly. Turning to specific pending matters before me, on 2nd October 2018, Mr. TURINABO submitted a motion to remove from the case record a confidential motion filed erroneously before me on 1 October 2018, which should have been directed to the President. I hereby grant Mr. TURINABO's request. I know that parties may also file a notice of withdrawal of a submission and do not, as a general rule, need to seek judicial authorization. In addition, on 7 December 2018, Mr. MUNYESHULI filed a motion for provisional release to the United States. The matter is in briefing. 3 other confidential motions are pending, and decisions will be issued in due course. Issues related to the material seized from Mr. MUNYESHULI will also be adjudicated in due course. It is my understanding that the parties and the senior legal officer met and had informal exchanges related to anticipated litigation and pretrial planning. I've been briefed on the discussions and anticipate having further consultations with the parties on these matters. I intend to issue an order for the pretrial work plan in January 2019. And now I raise the question, are there any other procedural matters related to the case that a party wishes to raise before I move on the health condition of the accused? And I direct the question first to the prosecution.
Your Honor, we have no issues to raise at this point. Thank you.
Thank you, Madam. And now I turn to counsel for Mr. TURINABO. You have any issues?
Thank you, Mr. President. I indeed have some issues I would like to raise at this time. I understand from what you have just mentioned, Mr. President, that we will be receiving an order for submissions in January. However, I believe that January might be a time that we could spend more effectively by resolving or at least by informing you of certain issues. Although these issues were the subject of informal discussions yesterday, some of these issues, we believe, must be placed on the record at this time. Mr. President, yesterday, the gist of the discussions were around when this trial could take place. We indicated on that point that the defense, and I'm speaking on behalf of Mr. TURINABO, that the defense for Mr. TURINABO is interested in a speedy trial as soon as possible, but that this requires some actions to be taken in order to allow the defense to prepare for trial. And I wish to very briefly mention some of these issues. The number one issue, Mr. President, is disclosure. So far, we have been working solely with the indictment supporting material. We have gone a certain way. We now need more, and we need the prosecution to disclose further material before this order of yours, Mr. President, is issued in January. The material we are looking for, first of all, arises from the Ngira-Batware case, which of course is not under your jurisdiction, Mr. President, we understand. However, we will be meeting with the prosecution after this status conference for the purpose of identifying exactly what material should be given to us by the prosecution as a result of a latest decision rendered by the appeals chamber, which is a public decision. That's why I don't move into private session at this time. It will be very important, Mr. President, for us to get this material without delay, and this is why I mentioned this at this time. There is a major issue going on, which is the link between the Ngira-Batware review proceedings and the proceedings in this case against Mr. TURINABO and others. The issue is the prosecution is in possession of all material. I'm not sure if you can hear me, Mr. President, because I can't hear myself anymore. But
I have no problem.
Then I will continue. The prosecution is in possession of all material from both the review proceedings as well as from the proceedings in this case. We have no idea what material from this case has been disclosed to the parties in the Ngirabatwari review proceedings, and it's our understanding that they also don't know what information or what evidence has been disclosed to us from the Ngirabatwari proceedings, other than for the decision rendered last Friday. This creates a situation of total inequality, with the prosecution knowing exactly what information and what evidence is available in the two proceedings, whereas the actors, the main actors in the other two proceedings, namely in this case, which is what this status conference is about, there's a lot of issues that we do not know what is going on, yet what the investigations being conducted by the prosecution at this point in time, we understand is directed at both proceedings. That's why we say that the prosecution should disclose the result of its investigation work, which is relevant and under the rules, we understand, but what comes from the prosecution's investigations and is relevant to this case, then should be disclosed now and not wait for us to submit motions. This is the first issue, Mr. President. Second issue is we have not received to this day any exculpatory evidence has been disclosed by the prosecution. It is possible the prosecution takes the view that there is no exculpatory information, but we take the view that there are, and we should be receiving exculpatory information. So, Mr. President, this is what is a major issue for us, which is preventing us from working quicker in order to be able to do this trial and to have a speedy trial. The second major issue, Mr. President, has to do with redactions applied to material. And again, I wish to say this at this point in time because waiting for January might be too long. We have been disclosed the indictment supporting material. This material for I will not say the most part, but a major part of the indictment supporting material has been disclosed with redactions. Redactions of names, redactions of places, redactions of. We don't know exactly what is the reason, what is the legal justification for such redactions at this time. In order for us to prepare and to meaningfully engage with our clients, we require to have this information, to have these redactions lifted at this time. For the time being, Mr. President, we invite you, a single judge, to order the prosecution at a minimum to provide justifications as to why this material is redacted. And we respectfully submit that saying that this material is subject to delayed disclosure is simply insufficient at this time. That is, Mr. President, the second point, which is a major impact on our work. The third issue I'd like to raise is that of preliminary motions. That was discussed yesterday. It is important for us to know when these motions will be due. We are working on these motions at this time. This will be a significant endeavor for the defense. Yet, we still have to be informed of what is the beginning of the period for which we need to file our preliminary motions. Of course, this is one of the pending matters before you, Mr. President, in terms of what the delay will be. It is true that this is all explained in the motion, so I will not go through that again. But it is important for us to know when these motions should be filed. Yesterday, we suggested to have the date of 31st January as a possible date for the filing of all preliminary motions. So I leave it at that. I think the rest you can be informed, Mr. President, through the informal consultations. The fourth and last issue I would like to raise at this time, which has to do with us doing the necessary work to prepare for trial, has to do with protective measures. This issue was raised yesterday during informal consultations, but it must be placed on the record. To our knowledge, based on the information that we have received, there are 5 relevant decisions on protective measures of witnesses. It is not easy for us to know what exactly we are able to do or not to do, and who we can contact under what conditions in this case, because all of these decisions arise from the indictment proceedings and not from these proceedings. So we need to know what exactly, which of these decisions apply to us so that we know which witnesses we are able to meet, under what conditions, so that we do our work, of course, in accordance with the rule, but also that we are able to work with our clients and prepare the case for the defense. This is what I wanted to say at this time, Mr. President, and I apologize for being so long. Thank you.
Well, thank you, Mr. Bourgon. You mentioned that you have have agreed with the prosecution to hold a meeting to discuss some of these issues. Ms. Wright, can you enlighten me on that?
Thank you, Your Honor. Indeed, we had a meeting, as my learned friend has said, with my colleagues and colleagues from chambers, where we discussed, in fact, all of the issues that he raised. And we had come to some agreement on how to proceed and move forward. So I'm actually surprised that he's raising them here. But it's also a good thing, because there are some issues that I believe my learned friend is coming from a position of misunderstanding of what the role of the prosecutor is at this point in time, especially in terms of disclosure. I think we did disclose all the supporting materials that we used for confirmation of the indictment. Our work, our investigations are still going on, and whatever we find, we will disclose according to the rules. I think my learned friend needs to understand that our responsibilities are guided by the rules and not by whether it works for him and his client or not. And I'd like, first of all, Your Honor, to point to the issue of disclosure of the Ngirabatware file. They did make an application for access to all of the Ngirabatware file, which we opposed, and a ruling came out saying that they can have access to some of those. And we have told them that we will work with them to give them. So, in fact, he raised it, that we need to see if we have an understanding of what the order said in terms of what type of material, the extent of material that we will disclose to them. And we agreed. And to my understanding, we are supposed to meet after this status conference to talk about that, so we'll tell them what we are preparing to disclose, and they'll know what to expect. And if it is not to their expectation, we try and find a common ground. Otherwise, we come back to the chamber. So that, I believe, has been sorted out. Your Honor, the other issue that he raised was about exculpatory material. That is governed by Rule 73. It is an ongoing obligation which the prosecutor is aware of. We are cognizant of that, and we will abide by our obligations under those rules. Already, if he looks at the material that has been disclosed, there are some exculpatory material. We have no interest to hide anything, and we will not do that. But we will disclose according to the rules. We have disclosed Rule 71 material, and we will disclose Rule 73 material as and when we come through across them. Your Honor, he raises another issue of not knowing what has been disclosed in the Ngirabatware review hearing. Indeed, we are the first to accept that these two cases are linked. In fact, this case arises from that one, but there are two proceedings. As the chambers, both appeals chamber and and Your Honor has consistently stated the two proceedings are related, but they're different. Therefore, we will disclose to my learned friends and his clients on this case according to the rules, like I said, governing disclosures in trial matters. And we disclose to Ngirabatware according to the rules governing the review hearing. We have not gone out of our obligations, neither have we withheld anything from defense in this case or in the other case as we move along. And we have been very transparent about that. Another issue is the issue of reductions. My learned friend raised this yesterday, and we did respond to that. We disclosed material in redacted form to protect witnesses according to witness protective measures that we have had. And in this particular case, Your Honor, protecting witnesses is very important. It is central to this case. It is central to the allegations against the accused persons before you. So we have to be careful what material we put out there to the accused persons as well as to Ngirabatware. We cannot expose material that has already been redacted for Ngirabatware's case and give it to them unredacted. And like I come back to the point, we will disclose unredacted material according to the rules, and the rules are clear that the court will order when we should give unredacted material, which at the minimum, is 30 days before trial. We don't even have a trial date yet, and counsel is insisting that we have to give them unredacted material. I think that goes out of the scope of the responsibility of the prosecutor. And in terms of the protective measures, I believe that senior legal counsel yesterday did inform us that they're going to look into that and will come up with, chambers will come up with directions as to how to go about that. But having said that, we amongst ourselves have discussed and we've thought, in order to make things easy for the court as well as our learned friends and their clients, that we pool together, because we have a good knowledge of all the different decisions that have come out of the Ngirabatware case that impact on the witnesses that we will be calling here. We will come up with a consolidated application or a consolidated draft ruling or whichever final format we will agree on. But most likely it will be a motion to the court where we pool together all the different decisions and make an application for the court to order protective measures specific to this case. And of course, at the end of the day, the decision lies in Your Honor's hands. But we are thinking that that would be able to help us move ahead so that we don't leave any loose ends for counsel, for protective measures to be infringed. But having said that, I think my learned friend should be aware that when there are protective measures, and he has said that he has seen 5 of them, he is bound by those measures. Whether he was involved with them at the beginning or not, counsel is bound to respect those protective measures and to ensure and assure that those protective measures are respected. Because, first and foremost, counsel is an officer of the court. I believe those are the 3 different issues, the 4 different issues that have been raised by my learned friend. If I've left anything out. Yeah. So that is our response, my Lord.
Thank you, Ms. Wright. Since the parties have already agreed on a meeting later, I suggest you take the meeting, and then if there are any outstanding disagreements, that you raise them before me. Would that be acceptable to you, Mr. Bourgon?
Indeed it is, Mr. President. This is my purpose in getting up at this point in time. We mentioned that we want a speedy trial. The object is this cannot take place unless we get full cooperation with the prosecution. There are issues missing. The sooner we resolve these issues, the sooner we can proceed with the necessary steps. I will not reply to what my colleague mentioned, but I will say one thing, is that although we believe that witness protective measures are of the utmost importance, we are true believers in witness protective measures, but witness protective measures cannot be an impediment to a fair trial. So the two must work hand in hand. We have not been informed inside of the indictment supporting material what is redacted. We don't know what is the legal justification. Saying that it is necessary to protect witnesses, in our view, Mr. President, is insufficient, and we will raise that with the prosecution at the meeting so that we have exactly under which rule the material presently redacted, which was available to the confirming judge but not to us. That's where the problem is, and we will be discussing that with them. We would like to avoid filing a zillion motions for disclosure. That's the point, Mr. President. Thank you.
Thank you, Mr. Bourgon, and I'll turn to counsel for Mr. NZABONIMPA and Mr. Roberts. Do you have any issues?
Thank you, Your Honour. Fortunately, due to the thorough explanation of the issues already given by my colleague, I have nothing to add, merely to echo and fully support what he said and hope that we can find a solution. The one minor point that I would add is obviously there are rules as the last possible date when you can disclose material. I would hope that in order to assist us to actually prepare properly, we actually take a slightly more practical approach to this and allow those materials to be disclosed earlier so that we can actually effectively prepare. We don't want to go purely down to the last day because that will undoubtedly lead to further delays. And in light of your referral decision, where you emphasised that one of the reasons justifying keeping the case here was to lead to an expeditious trial, I think that should be taken into account in every decision in relation to disclosure and redactions and any other necessary measures that need to be taken in order to prepare for trial. But beyond that, I don't think there's anything that I need to raise at this juncture. Thank you.
Thank you, Mr. Roberts. And now, counsel for Mr. NDAGIJlMANA, Mr. Nderitu.
Thank you, Your Honour. I only want to associate myself with Mr. Bourgon and Mr. Roberts.
Okay. Thank you, Mr. Nderitu. And now, counsel for Mary Rose FATUMA, Mr. Kashabana.
Thank you very much, Mr. President. First of all, I would like to raise an essential point. We have sought to have a closed ex parte meeting for matters specifically concerning my client, and I believe that after yesterday's meeting, we were made to believe that that meeting would be able to take place after this current status conference, and we are available to meet you, if possible, together with the prosecution in order to consider these issues together. And this is what I am saying by way of introduction. As for the rest of the issues, there's the matter concerning the disclosure of materials, which is a thorn in the flesh of the defense at this juncture. As far as we are concerned, we are also experiencing this problem concerning disclosure of materials. I heard the representative of the prosecution state that a solution could jointly be found during the joint meeting of the parties, and I take due note of that. But this meeting should take place as soon as possible so that we can respect the contradictory debate. As for disclosure per se, there are documents that are still missing to date, and this has placed us in difficulty in order to conduct a defense for our client as best we can, but we have tried to address the prosecution in this regard, and in its reply, we were told that they can help as much as possible. But we can state, Mr. President, that for a week now, when the status conference was approaching, that's when the prosecution began to make bit-by-bit disclosure. So we are having some difficulty given this delay, and we hope that following the meeting that we are expecting, that this matter will be addressed. As for the production of disclosure of documents, Madam Fatuma Mary Rose, whom I represent, only speaks Kinyarwanda. Since the proceedings began, be it motions or your decisions, be it even we ourselves who speak with her, the languages that we use are the official languages of the mechanism, which are English and French. As far as a motion is transmitted or any procedural document is issued, we need to have the same in the single and only language Kinyarwanda that my client uses. When Kinyarwanda comes up only at the very end of the matters at hand, I think we need to look at this specific issue so that there are urgent and exceptional measures taken which would enable Ms. Marie-Rose Fatuma to have documents she needs in the Kinyarwanda language as soon as is possible. And we wish to have this happen simultaneously as documents in other languages are produced. Because when she receives documents in a language she does not understand, I don't know how you would look at this, but I find that in Rwanda, as it also applies here, I have to wait until I get here before I receive materials in the relevant language. So I would appeal to your honor to ensure that something is done to ensure that this problem is solved once and for all. It's a real problem. It's a true problem. It's the right of the defense, and this should apply to all situations that we come across. Mr. President, that is the essential matter which I request you to give your urgent attention such that urgent and exceptional matters be provided. Now, my next point deals with redacted materials. There also we have a real problem. The prosecution has said to us that disclosure will be made in respect of the rules. But I'm wondering, Mr. President, should it apply only to the prosecution because there is a violation of the absolute right of the defense, and the defense cannot defend itself because a declaration made by the prosecution finds that there are documents that are redacted. So, Mr. President, we are faced with quite a significant number of difficulties. There is also the matter of certain matters that remain pending concerning preliminary motions, concerning the position raised by my eminent learned friend Stéphane Bourgon and Jeffrey Roberts, and there's also the protective measures. So we do associate ourselves with what has been said by our learned friends in their earlier submissions. I thank you.
Thank you, Mr. NDAGIJLMANA. The first issue you raised with respect to an ex parte meeting you and your client will be granted. We will take it in continuation of this proceeding. With respect to the translation into Kinyarwanda, I will look into what the possibilities is with the registry, but translation takes time, and there are some documents that are very central to an accused to be able to peruse and understand on her own, and there are other documents that a counsel can be expected to explain the content of until the translation comes. So we have to prioritize these different type of documents. But we'll look into what can be done. And with respect to the redactions, you will get the material eventually and get the time for preparation. The issue about when it is disclosed to you in full is a matter of expediency and whether or not this trial will be more or less speedy. And of course, we all work towards concluding the trial as soon as possible. But this case is very complicated because of the link to the Ingabatuari team, the Ingabatuari case, and because all the decisions that have to be respected in connection with the disclosure have been taken by the appeals chamber in the Ingabatuari case. But hopefully you can find some practical solutions in your meeting with the prosecution. If not, you will have to raise it with me more specifically. Now I turn to the situation and health of the accused, and we have already dealt with Mr. Fatuma. I would like to inquire whether any of the accused have a health concern that they would like to raise. Oh, sorry. I forgot you, Mr. MUNYESHULI.
It's really not a problem, Your Honor, because my colleague said everything I would have said, so thank you.
Okay.
We're fine.
Well,
yeah.
That's what I assumed, so thank you. Turning back to the health situation, does any of the accused want to raise a health issue? And if so, we can discuss it in a private session or, if necessary, in an ex parte session. That's only Mr. NDAGIJLMANA, I note.
Mr. President, also on behalf of Mr. TURINABO also, I'd like to make some certain submissions regarding the health situation of my client, and I'd like to do that in private session, please. In private session.
So we take the private session before the ex parte session for technical reasons. So
we're in open session.
Thank you, Madam. Mr. Vagn, you can continue.
Thank you, Mr. President. There is one issue which is kind of difficult for my client. Again, I speak on behalf of my client and leave to my colleagues whether to join or not in this submission, and is the duration of the telephone calls he is able to make from the detention facility. I've discussed this briefly with the commanding officer of the detention facility. Mr. TURINABO, as the other four accused, is subject to certain restrictions at the detention facility. We understand that. But one of those, what he is able to do pursuant to these restrictions is to call his immediate family. At this point in time, Mr. TURINABO is limited to 5 minutes per week. Mr. President, we say that this is insufficient. These five accused and Mr. TURINABO are still presumed innocent, and they are detained for preventive measures and not as a punishment. To allow Mr. TURINABO to call his wife only 5 minutes per week, we say is not sufficient. And I invite you, Mr. President, simply to consider for yourself whether this is proper in the circumstances. We believe that arrangements can be made, and I will try to meet with the commanding officer again to have this changed. But we believe that this is something that needs to be brought to your attention, the duration of telephone calls. And what we suggest is we have two possibilities. We will be two options we will be discussing with the commander. The first one is using the time allocated to Mr. TURINABO to call his counsel to do away with this time, which is 15 minutes per week, and to add this to the time he can call his immediate family, namely his wife. The other one is simply to authorize a little more. 2 phone calls per week of 20 minutes would not appear to be excessive, and I think can be entertained by the existing resources within the detention facilities. We believe that this can make a huge difference in the morale of the accused and their ability to prepare their defense. Thank you, Mr. President.
Thank you, Mr. Bourgon. There's a special complaint procedure for the detention matters. The first instance is the commander, who you're already addressing, and his decisions you can bring before the registrar, and finally you can bring the registrar's decision before the president of the mechanism. So although I might have opinions about these matters, they don't count here. It's first the registrar and then the president you'll have to address. But now you have it on the record, at least.
Your Honour, just briefly, I would just fully support the application by Mr. Bourgon. Obviously, I recognise this may well be the wrong forum to bring it up, but certainly the principles from Rule 12 from the rules and Regulation 9 from the specific regulations in relation to supervision of visits implies very clearly that there should be a certain flexibility in how these are produced and how they are applied, and certainly we will follow that together with the other accused.
Okay. And there are no other issues that the parties want to raise, including the prosecution?
None, Your Honour.
Okay. Thank you, Ms. Wright. So I thank the parties for their cooperation in getting this case as far as it is, and this concludes the main portion of today's status conference. And we'll take a break to arrange for the ex parte session with Mrs. Fatuma and her counsel. Thank you.